And greetings. Welcome to Jurisdiction, the Power of a Court from American Jurisprudence. I'd like to welcome everyone here. I'm going to get the chat all set up here. I see everyone here. Welcome to Thompson from MySpace. I haven't seen that one in a while. And yeah, please hit the like volume low. Let's fix that right now. Like, all right, we're just getting the volume adjusted here. Volume. Okay, we should be at maximum volume now. If everything is loud and clear, just let me know in the chat, and let's get going. Now volume is low. All right, well, this is as loud as I can get here. I guess the music was a bit loud. Check, testing. So today we're going to be going over jurisdiction from second edition American Jurisprudence Courts. So on section 53 is where it starts, and generally. All right, sounds like we get good sound now. Excellent. Okay, let's see here. All right, here we go. Although the term jurisdiction sometimes refers to the power or authority of agencies other than the courts, or to the power and authority of a state as a whole, the jurisdiction discussed here is the non-appellate jurisdiction of state courts in civil cases. The concept of jurisdiction embraces a large number of ideas of similar character, some fundamental to the nature of any judicial system, some derived from the requirement of due process, some determined by the constitutional or statutory structure of a particular court, and some based upon mere procedural rules, originally devised for convenience and efficiency, and by precedent made mandatory and jurisdictional. Jurisdiction has been defined as the power of a court to hear and determine a case or cause of action, or issue a decree. In its fundamental sense, jurisdiction refers to a court's power over persons and the subject matter, but also refers to the power to render the particular judgment sought, or, as it is sometimes said, jurisdiction of the particular case. Jurisdiction transcends all procedural considerations and involves the fundamental power and authority of the court itself. We have a caution here. Statutes merely addressing which court shall have jurisdiction to entertain a particular cause of action can fairly be said merely to regulate the secondary conduct of the litigation and not the underlying primary conduct of the parties. Such statutes affect only where a suit may be brought, not whether the suit may be brought at all. And we're going to get into this with more depth. So, in our cumulative supplement here, we have some cases. Jurisdiction is a concept reserved for delineating the classes of cases, or subject matter jurisdiction, and the persons, or personal jurisdictions, falling within a court's adjudicative authority. All right, and we see here is footnote 3 is to the appellate jurisdiction of state courts. This is different ones in AmJur to refer to. As to jurisdiction over the person and the subject matter, see section 68, which we should be getting to soon. All right, we're on to distinctions, where we're going to go over venue and jurisdiction. Although venue has sometimes been treated as jurisdictional in nature, and the concepts jurisdiction and venue have a close relation. The two concepts are distinct, as every word has a different meaning than another word. Venue, in the technical meaning of the term, means the place where a case is to be tried or heard, while jurisdiction refers to the power of the court to adjudicate or hear and determine the merits of the case. So once again, the venue is a technical meaning, right? And it's a place where the case is to be tried or heard. And jurisdiction refers to the actual power of the court to hear and determine the merits of the case. Jurisdiction is the power to decide erroneously as well as correctly. Wow, that's pretty significant here. Jurisdiction is the power to decide erroneously as well as correctly. Stated otherwise, courts do not lose subject matter jurisdiction merely by interpreting the law erroneously. Interesting. And let's see here. That's in Marriage of AmJur, 1993. That'd be an interesting case to look up. Okay. And as we have here from Thompson from MySpace, as he mentions, the jurisdiction is law, right? Say show is akin to control, as we say here, is the power. So the power of control. Nice. And let's proceed. Courts may derive their jurisdictional power from the Constitution and from legislature. And this is on, what are we on here? Oh, Constitution and legislation as sources of the jurisdiction. So we have Constitution and legislation. So courts may derive their jurisdictional power from the Constitution and from legislature. Conversely, a court possesses no jurisdiction where the Constitution or legislature expressly denies jurisdiction. In a state in which the Supreme Court is the only court of original jurisdiction, here's an interesting concept right here that they even mention. In a state which the Supreme Court is the only court of original jurisdiction, coextensive in the arena of its exercise with that of the sovereignty which created it. Its jurisdiction is general, unlimited, and unqualified, and the legislature has no power to limit or qualify it. When the jurisdiction of a court is fixed by a constitutional provision, the legislature is powerless to abridge or enlarge the constitutional jurisdiction of the court. Wow. So we have a push and pull between the legislature and the Constitution. The authority to determine the jurisdiction of a state's courts may be vested exclusively in the legislature. In such an event, the jurisdiction of the court is limited to whatever the legislature may choose to bestow. Where the legislature has exclusive power to create courts, this power to create a court carries with it the power to define its jurisdiction, and therefore, municipal ordinances cannot constitutionally impair or restrict jurisdiction granted to a court by the legislature. And in fact, I believe that legislative courts may only have jurisdiction within the legislative branch. But I'm not sure about that. Let's read a little bit further down here and see this caution. The principle that the jurisdiction of a particular court is limited to whatever the legislature may choose to bestow may not be applied to shield the legislation from judicial review or deprive the courts of the jurisdiction to enforce a constitutional right. Interesting here. Observation: statutes addressing which court has jurisdiction to entertain a particular cause of action regulate the secondary conduct of the litigation and not the underlying primary conduct of the parties. They affect only where a suit may be brought, not whether it may be brought at all. So this is with the statutes, this is within our legislature, address which court has jurisdiction to entertain. Okay, if there are such statutes, a particular cause of action, they'll regulate the secondary conduct of the litigation, not the underlying primary conduct. They affect only where the suit may be brought, not whether it may be brought at all. So they may deny jurisdiction or venue of one court, and then you'll have to file it in a different court, I would assume here from what it seems from this observation. Again, nothing here is to be construed as legal lawful information, not to be used for your professional, private, legal lawful, or business ventures or other types of activities. Don't do this at home. State jurisdiction over certain cases rests on federal statutes presumptively or explicitly permitting jurisdiction in the state courts. Now look at this one, it's very important. State jurisdiction over certain cases rests on federal statutes. I'm sure this refers to bankruptcy. Presumptively or explicitly. See, there's a lot of presumptions they'll be using here, and it may be explicitly permitting a jurisdiction in the state courts. Wow. Cumulative supplement cases. Mandatory prescriptions, however emphatic, are not necessarily jurisdictional. That's Connecticut, 2016. And all we have here are case citations. No footnotes other than that. And now we get over to jurisdiction over foreign countries. And before we do that, we need to check up on the chat here. And it says, of course, jurisdiction. I'm going to have to read a little bit from the chat because it didn't fit on the screen. Jurisdiction or power to charge. Why would I, a vessel or battery, go there as a source to charge? Well, they want your charge is what they want. They're taking your charge, right? Does a court have jurisdiction if you are not served? Well, there's something weird. I don't know if we've mentioned it or not. Yes, we have. So due process is part of jurisdiction. If they haven't followed due process, how could they have jurisdiction? And I believe that service, is part of your due process. So let's see here. Service summons is to give an invitation. Say you can't make it, but if you ignore, you RSVP as, I'll show up in the court. In the court's, eyes. Got it. Okay. Excellent. Yeah, so that's some good input here. But yeah, again, the jurisdiction, if you haven't had your process of service, then how could they gain jurisdiction? That's part of your due process is jurisdictions established through that. I think we gave in the preface here. So we should be getting into that in more depth too. So great. Let's proceed here and continue on down with jurisdiction over foreign countries. Under the Foreign Sovereign Immunities Act, a foreign state is generally immune from the jurisdiction of state courts. However, exceptions to the general rule of immunity exist where, here we go, the foreign state has waived its immunity. The action is based upon a commercial activity carried on in the United States by the foreign state, or upon an act performed in the United States in connection with a commercial activity of the foreign state elsewhere, or upon an act outside of the territory of the United States in connection with a commercial activity of the foreign state elsewhere, and that act causes a direct effect in the United States. Notice how they're using United States, not United States of America. Rights and property taken in violation of international law are an issue, and such property or any property exchanged for such property is present in the United States in connection with a commercial activity carried on in the United States by the foreign state, or such property or any property exchanged for such property is owned or operated by an agency or instrumentality of the foreign state, and that agency or instrumentality is engaged in a commercial activity in the United States. Okay, I think we covered it pretty well there. Oh, no, we haven't. There's more. Here's some works. These are all exceptions, right, to the sovereigns under the Foreign Sovereign Immunities Act. Is generally immune except rights in property in the United States acquired by succession or gift, or rights in immovable property situated in the United States are an issue. So property. The general exception relating to commercial activity is inapplicable and money damages are sought against a foreign state for personal injuries or death. See, this is the general exception related to commercial activity is inapplicable. An exception is if the general exception relating to commercial activity is inapplicable and money damages are sought against a foreign state for personal injuries or death or damage to loss of property occurring in the United States and caused by the tortious act or omission of that foreign state or any official or employee of that foreign state, while acting within the scope of his or her office or employment. This exception does not apply to any claim based upon the exercise or performance of the failure to exercise or perform a discretionary function regardless of whether the discretion has been abused, nor to any claim arising out of malicious prosecution, abuse of process, libel, slander, misrepresentation, deceit, or interference with contract rights. That sums it up pretty well there. Let's take a quick reprieve here to the comments here. Yes, and Thompson from MySpace also says the court has jurisdiction if you let them. It is established in many ways. Yes, if the court believes you know of a date and they know you to be the citizen or defendant, they have jurisdiction. So yes, there's elements to it. I think they also call minimum contact and such where they can establish it. There's ways where even appearing as a special appearance can still allow them to have jurisdiction. I think there's elements that should be observed in that too when you're talking about jurisdiction. Again, we're going to get in depth. Right now, we just want to get these foreign ones out of the way because as much as it may seem like something that it might not be commonplace, the foreign immunity to jurisdiction is something that people that are here in America don't want our land abused, our rights abused by foreign actors. Therefore, there are these exceptions. We should be aware of these exceptions so we're not taken advantage of here on American soil. The action, let's see here. The action is brought either to enforce an agreement made by the foreign state with or for the benefit of a private party to submit to arbitration all or any differences which have arisen or which may arise between the parties with respect to defined legal relationship, whether contractual or not, concerning a subject matter capable of settlement by arbitration under the laws of the United States, or to confirm an award made pursuant to such an agreement to arbitrate. If the arbitration takes place or is intended to take place in the United States, the agreement or award is or may be governed by a treaty or other international agreement in force for the United States, calling for the recognition and enforcement of arbitral awards. The underlying claim could have been brought in a United States court or the foreign state has waived its immunity. Boy, we're getting a little in the weeds here. Money damages are sought against a foreign state for personal injury or death that was caused by an act of torture, extrajudicial killing, aircraft sabotage, hostage taking, or the provision of material support or resources as defined for such an act, if such act or provision of material support or resources is engaged by an official, employee, or agent of such foreign state while acting within the scope of his or her office, employment, or agency. Wow, talk about getting shadow banned with these kind of words here. A counterclaim is brought for which the foreign state would not be entitled to immunity had such claim been brought in a separate action against a foreign state, or which arises out of the transaction or occurrence that is a subject matter of the claim of the foreign state, or to the extent the counterclaim does not seek relief exceeding in the amount or differing in kind from that sought by the foreign state. The Act also provides limitations period on personal injury or death suit caused by torture, extrajudicial killing, aircraft sabotage, hostage taking, or providing support for such act of 10 years. Oh, Lord. The Act is applicable where a defendant is a foreign state or an agency or instrumentality of a foreign state at the time the lawsuit is filed, irrespective of whether the defendant was a foreign state at the time of the injury which gave rise to the lawsuit. So even if the foreign state's no longer a foreign state, I guess, I don't know, the instrumentalities or agencies, you would be able to hold for account. The Act extends to commercial manufacturers where in excess of half of the manufacturer's stock is owned by a foreign country at the determinative moment of the suit. Courts are generally hesitant to find that a sovereign has waived its immunity. And moreover, international organizations may only dissolve their absolute immunity through express waiver. So the courts are generally hesitant to find that they've waived immunity. Sanctions may be imposed against a foreign country under the authority of the Act, provided that the court balances its own interests with the issues of the state sovereignty and international. Well, this isn't going to affect any of us for sure. I don't think we're going to see sanctions imposed because we can't get our day in court with the foreign agents here. Federal courts are not granted exclusive jurisdiction to hear suits brought against Foreign Sovereign Immunities Act. Federal district courts have exclusive jurisdiction over civil actions against a foreign state, regardless of the amount in controversy, provided that the foreign state is not entitled to immunity under the Foreign Sovereign Immunities Act. Commercial activity, which may form the basis of a suit under the Act, extends to contract actions and to sexual harassment. Gosh. That looks like 19. We'll have to look at footnote 19. I'm sure that's something current. 1993. Superintendent of Merchant Marine. Wow. Okay. Under the Act, subject matter jurisdiction plus service of process. Okay, we get subject matter jurisdiction plus service of process equals personal jurisdiction. So we're saying under the Act, but I think it's a question was presented earlier that subject matter jurisdiction plus service of process equals personal jurisdiction. And I think that's a generalized statement there, but that's something that you could work with. Immunity is lost if a case is allowed to go to trial. A breach of contract claim falls within the commercial activity exception where neither party disputes a contracted issue allowed a nonprofit corporation to operate as a South Korean company's United States branch. Taekwondo Committee. An act issue, okay, falls commercial activity. An act of issuing a letter of credit falls within the scope of commercial activity as defined by the Foreign Sovereign Immunities Act. Interesting. Don't want to try and pronounce that. 2008 though. So just the timing of this one kind of lets you know. These foreign banks issuing letters of credit falls in the scope of commercial activity. There's a lot of U.S. code there to refer to. Republic of the Philippines versus Westinghouse, 1994. Ooh, interesting. Here's our Merchant Marine one. And this one here, Westinghouse. And that's pretty current for something like that with Westinghouse and Republic of Philippines. Sanctions be, oh wow, sanctions. Provided the court balances its own interests with the issues of state sovereignty and international comedy and considers less drastic sanctions that do not interpose the court into the foreign country's law enforcement functions. That's an interesting one there. So I guess it did have an issue there with sanctions coming out of the act. All right, so back to the land of milk and honey here. Section 57, power and duty to determine jurisdiction. And before we go on to this, let's double check on our chat here. Yeah, establish your fees, conditions, titles, and you establish your boundaries for the court and its gestures. Nice. Indeed. All right, let's proceed. So this is the power and duty to determine jurisdiction. Power and duty. This is an interesting one here. Duty to determine jurisdiction. Who has that duty? A court has the power and duty to examine and determine whether it has jurisdiction of a matter presented to it. Jurisdictional tests, often applied at the outset of a case, should be as simple as possible. While trial courts possess all the authority to initially determine their own jurisdiction, the determinations can be challenged. Welcome there, Mom Dukes. A court may raise a question of subject matter jurisdiction sua sponte at any time during the action, even on appeal. So, court may raise this question of subject matter jurisdiction at any time and even on appeal. Nevertheless, because the orders and judgments entered by courts without jurisdiction over the subject matter of a dispute are void, issues regarding a court's subject matter jurisdiction should be considered as a threshold inquiry and should be resolved at the earliest possible opportunity. Indeed, the question of jurisdiction should be considered by the court before it looks at other matters involved in the case, such as whether the parties are entitled to a jury trial. It may and must do this on its own motion. Courts are bound to take notice of the limits of their authority. And if a want of jurisdiction appears at any stage of the proceedings, original or appellate, the court should notice the defect and enter an appropriate order. If the defendant makes a prima facie evidentiary showing that the court has no personal jurisdiction on a motion to dismiss for lack of personal jurisdiction, the plaintiff is then required to substantiate the jurisdictional allegations in the complaint by affidavits or other competent proof, and may not merely reiterate the factual allegations in the complaint. So, anyone having any questions on this, this is pretty thorough right here, what we just went over, this simple section here. The court has the duty to examine and determine, and not only is it applied at the outset, but the court has to initially determine their own jurisdiction. And not only that the courts are bound, here we go, courts are bound to take notice of the limits of their authority. And if a want of jurisdiction appears at any stage of the proceedings, a want of jurisdiction, original or appellate, we're really only talking about original cases in this presentation, the court should notice the defect and enter an appropriate order. Now, we have the word should, but they're bound to take notice. But they should write notice to the defect and enter an appropriate order. So this is something where you can't hold them account to do, but they're bound to take notice. But they should notice the defect and enter the order. So I'm not sure what footnote 11 is going to expound on, but let's see. Polk County This is in Florida, 1997, versus Sofka. So this would be an interesting one to look at. And that's from the Florida Reporter, 1997. So interesting, that's just an interesting concept right there to know, that the courts are bound to take notice of the limits of authority. And if the want of jurisdiction appears at any stage of the proceedings, the court should notice the defect and enter the appropriate order. So, if the defendant makes, we had this part here, let's go over the cumulative supplements here with our cases. Evidentiary hearings in airline suit to recover for airplane engine explosion over Texas was necessary to resolve disputed issues as to United Kingdom's repair contractor's connection to delivery of engine in Florida and specific personal jurisdiction over contractor. So this came Florida statute annotated, huh? Rolls-Royce versus Spirit Airlines. And that's in the 4th District Court of Appeals, 2018, not very long ago. And that's the evidentiary hearing was necessary to resolve disputed issues. So, connection for delivery and specific personal jurisdiction over contractor. So, guys, this is evidentiary hearing. Look into what those are, because that's another way to challenge specific personal jurisdiction. To determine whether a Montana court may exercise personal jurisdiction over a non-resident defendant, Supreme Court first determines whether the personal jurisdiction exists. If so, it then determines whether the exercise of personal jurisdiction conforms with the traditional notions of fair play and substantial justice embodied in the Due Process Clause. Court must rule upon the jurisdictional issue unless it is so bound up. An example, intertwined with the merits, that a full trial on the merits may be necessary to resolve the issue. As a general matter, jurisdictional issues not flagged by the party may, and sometimes must, be raised by the reviewing tribunal sua sponte. So that's, which one's this? Okay, so it's not in the footnote. This is just in our cumulative supplement. Nice. 2014, yeah, so these are current. That's why it's in the supplement. This is a good one here. As a general matter, jurisdictional issues not flagged by the parties may, and sometimes must, be raised by the reviewing tribunal sua sponte. Subject matter jurisdiction may be challenged at any time and may be raised by a court on its own motion, even if the parties have not raised the issue. That's in Turner versus Turner, Tennessee, 2015. So there we go. Some current cases to support the facts that we just read. And some more citations here. As to how and when an objection to jurisdiction may be raised, generally see section 61. We'll be there very shortly. We're on 58 here. And this is power and duty to determine jurisdiction. Jurisdiction to issue ancillary orders. Jurisdiction to determine jurisdiction doctrine. The jurisdiction to determine jurisdiction doctrine, that seems redundant, relates to the authority of the courts to issue ancillary orders while considering other questions, including determination of their own jurisdiction, and to punish as criminal contempt violations of such orders, even though it may later be judicially determined that the court lacked jurisdiction over the proceedings in which ancillary orders were issued. Moreover, even where a dismissal is deemed jurisdictional, a court may determine matters ancillary to the underlying action as cost and attorney fees. A trial court has the authority to issue orders necessary for the protection of the parties during the time it makes its jurisdictional determination. So decision clarifying other grounds as the lack of jurisdiction on orders of the court. So we're on to duty to exercise jurisdiction. Excellent. Generally, a court with jurisdiction over a case has not only the right but also the duty to exercise that jurisdiction. However, a trial court may have discretion to decide whether to decline to exercise jurisdiction, as where the assumption of jurisdiction would require the court to interfere with the internal management of a voluntary association, in which case the appellate court will not reverse the court's decision absent an abuse of that discretion. Nevertheless, the erroneous failure of a trial court to exercise its discretion is reversible error. State courts are not free to decline the jurisdiction conferred on them by Congress in cases based on federal statutes if such cases are within the scope of the ordinary jurisdiction of the state courts as prescribed by local laws. The court's duty to exercise this jurisdiction can be enforced by way of mandamus proceeding. In certain situations, a court having jurisdiction over a case may, in its discretion, decline to exercise it, as when the doctrine of forum non-conveniens is applicable. Moreover, the court should generally decline to exercise jurisdiction in a case seeking a declaration of non-liability in a tort suit, because to do so deprives a potential plaintiff of the right to determine where and when to file a suit. So, a court possessed of subject matter jurisdiction generally must exercise it. This is an important one to know too. This is Texas 2008, so special retailers versus state. It says Uniform Child Custody Jurisdiction Enforcement Act, yikes. As to state court jurisdiction over federal causes of action, see Section 87. As the doctrine of forum non-conveniency. Well, okay, I don't know if we're going to get that far tonight, but let's continue down here. Here's Section 60, jurisdiction as dependent on application for relief. And before we get down to this, let's double check onto the chat. Yeah, traffic. How does the court determine jurisdiction? I think you end up doing that here. For me, what I've been doing, how they get jurisdiction is by giving up our birth date. No, I don't know if that's enough there, really. Zip code could do it, though. All commercial. Yeah. Any stage of the proceedings, jurisdiction can be challenged, and it must be challenged. It's the duty of the court to do that anytime it sees a reason to do it at that moment. All right, let's proceed. Okay, the general rule, and now we're on to the jurisdiction as dependent on application for relief. So the general rule is that a court cannot adjudicate a controversy on its own motion. It can do so only when the controversy is presented to it by a party, and only if the case is presented to it in the form of a proper pleading petition. Thus, before a court may act, there must be some appropriate application invoking the judicial power of the court with respect to the matter in question. Now, I need to just break in here a little bit here. Proper pleading, footnote 2. Kill Devil Hills Police Department. Okay. A problem with this is that by pleading, you are admitting to the genius of the record. And also the fact that once you've done that, you've also given an element of minimum contacts. That's jurisdiction for sure. But more important is the fact that in the form of a defense, it's probably not the best thing to do if there is controversy involving facts, perhaps, that some of these things should be challenged before a pleading. However, if you're on the plaintiff side, then the petition be a better word to use here, but I guess that would depend on your rules of procedure and what you feel comfortable doing there. But again, it's just opinion here. And you'll never see a court questioning its own jurisdiction as its duty requires. So you put them on judicial notice, and you can bring up these cases in that judicial notice. Is the whole purpose of this? Is that sometimes, oftentimes, that you really do have to compel the court to do its due diligence, and that's just the nature of the courts. I mean, after all, judges don't write orders. The esquires do, and they set the calendar, and their secretaries, and the judges do very, very little. And considering that, just by habit, I can't see them going through such motions against themselves and getting so involved without feeling like interlopers at that point with the case at hand. They just want to be the presiding officer. So I kind of get that. However, if someone needs to take notice, if the judge takes notice, it says they should do this and that. So if they don't, then it's your due diligence to put them on notice to do that. So it wouldn't necessarily be you would put in a motion for a challenge of jurisdiction or such. You would just put a judicial notice on what you believe is facts and law, and you would ask a good honorable judge in their good court to to uphold the legal process and to do the right thing. I would assume. Again, I'm not giving any kind of legal advice, but it seems that way. That being said, let's continue here. Subject matter jurisdiction is jurisdiction over the nature of the case and the type of relief sought. Subject matter jurisdiction, nature, and type of relief. Among the various trial courts is both conferred and limited by statute in state courts. The power to award relief is an essential component of subject matter jurisdiction and may be restricted by a statute limiting the kinds of relief that can be rendered in certain kinds of cases. The courts thus must have jurisdiction over the nature of the case and the type of relief sought, money. In the exercise of special statutory jurisdiction, if the mode of procedure prescribed by statute is not strictly pursued. No jurisdiction is conferred on the circuit court. Jurisdiction is conferred when a court has general power over matters of the type involved in a particular case. The proceeding is initiated in a particular manner required, and there is notice to the parties. You get that? 3 things is mentioned there. Has general power over the matters of the type involved in a particular case. The proceeding is initiated in a particular manner required. Motions, pleadings, petition, whatever they're saying here. And there is notice to the parties. Okay, makes sense. All right, now we're on to the good stuff here. Section 61, Objections to jurisdiction, waiver of, or estoppel to assert, objection. So now we're getting to where the rubber meets the road. The parties cannot confer subject matter jurisdiction on the court, either by waiver, by consent, or estoppel. See footnote 2 here real quick if there's anything important here. Nope, just the citations. A party cannot waive an objection to a court's subject matter jurisdiction. So you can't waive an objection. On the other hand, an objection that the court lacks personal jurisdiction over a party can be defeated by a waiver or estoppel. Thus, a party generally may not object to jurisdiction of the person when he or she has failed to raise the objection. A defendant asserting lack of personal jurisdiction by special appearance has the burden of negating all bases of jurisdiction. See, this is tricky here. A defendant asserting lack of personal jurisdiction by a special appearance has the burden of negating all bases of jurisdiction. So this is why it's probably even a special appearance is not going to shield a party from personal jurisdiction, or any jurisdiction for that matter. Once a timely objection to jurisdiction is raised by a non-resident defendant, non-resident, not contracted within that state, municipality, affirmative conduct inconsistent with the objection is necessary to support a finding that it has been waived. There are various types of conduct that constitute a waiver of the defense of lack of personal jurisdiction, such as seeking affirmative relief that is inconsistent with an initial defense of lack of personal jurisdiction. See, this is why the coherency of the case. If you do an affirmative defense that's inconsistent with an initial defense of lack of personal jurisdiction, you'll lose that lack of personal jurisdiction defense. Or filing permissive counterclaims and cross claims, or requests that a court take jurisdiction of a proceeding. See, so some of these things are somewhat bad faith, I guess you could say, and that's why they're not acceptable. An objection based on the ground of absence of jurisdiction over the subject matter must be considered and can be raised at any time, even on appeal. Absence of jurisdiction over subject matter must be considered and can be raised at any time. Powerful words here. Must. Footnote 10 and 11. Let's see if we have anything. So 10, 2008, 2010, 9, okay. And 11, 2002. Some pretty good stuff here. Let's read our cumulative supplement here. The cumulative supplement has some little outlines of these cases here. Under certain circumstances, the lack of personal jurisdiction is subject to waiver. An example, defects in personal jurisdiction can be waived, which distinguishes personal jurisdiction from subject matter jurisdiction, which may not be waived. Interesting. A litigant generally may raise a court's lack of subject matter jurisdiction at any time in the same civil litigation, even initially, at the highest appellate instance. A delivery company waived its objection to the court's personal jurisdiction on appeal. In action brought by buyer of antique desk against company over property damage that allegedly occurred during delivery, where the company filed general appearance and answer, but not a special limited appearance solely to contest jurisdiction. A special limited appearance, another good term here. But this is where the delivery company waived its objection by its conduct, right? Because it filed a general appearance and answer, and not a special limited appearance solely to contest jurisdiction. Again, as we read over here, that you can't be waiving it when you have a, let's see here. Yeah, negating all bases of jurisdiction. So if you're asserting a lack of personal jurisdiction by special appearance, you have the burden of negating all bases of jurisdiction. However, if you come in on a general appearance, well, then there's nothing to negate. You've just acquiesced to it all. After the plaintiff makes a prima facie case showing that personal jurisdiction is appropriate, the burden shifts to the defendant to rebut that showing. Okay. Particular case jurisdiction is subject to waiver. Particular case. Wow. When a non-resident defendant seeks dismissal for lack of personal jurisdiction, so this particular case jurisdiction may have to do with contracts. When a non-resident defendant seeks dismissal for lack of personal jurisdiction, the plaintiff has the burden to establish that the defendant's contacts with the forum state were sufficient. Non-resident defendant. So if you're not a resident of that state, no contracts of that state, seeks dismissal for lack of personal jurisdiction. Now the plaintiff, that's if the defense is non-resident, plaintiff has a burden to establish the defense contacts with the forum state were sufficient, minimum contacts. Although the plaintiff, the party seeking to establish a court's personal jurisdiction over the defendant, has the burden of showing a prima facie case of jurisdiction, jurisdiction need not be proved by a preponderance of the evidence until trial or until the court holds an evidentiary hearing. Again, evidentiary hearing. So before we end tonight, that's the end of the supplement, and I don't think there's anything in these footnotes here. The next part here we get onto is the effect of fraud in obtaining personal jurisdiction. We'll read this one real quick and then we'll be closing out, but there's one more thing we're going to have, one more thing before we close out tonight, after this. So in a civil case, a court will not exercise jurisdiction which rests on service of process on a defendant who has been decoyed, enticed, or induced to come within the court's reach by any false representation, deceitful contrivance, or wrongful device for which the plaintiff is responsible. Okay, that's a lot there. If a defendant is within the jurisdiction of the court by means of fraud or trickery of the plaintiff, no act accomplished thereby can be allowed to stand. There is very little difference between enticing a person from one jurisdiction to another for the purpose of getting process on him or her, and by carrying a person by force from one jurisdiction to another to be served with process. Wow. Look at that. The basis for this rule is not that the court did not acquire jurisdiction, but that it should abstain from exercising jurisdiction in view of the unfair manner in which it was procured. All right, so deceit, service, deceit through service. So effect of lack of jurisdiction. All right, I guess this is where we have to end it out because this will bring us to a close where then I can bring on to one more thing before we end. The proceedings of court without jurisdiction of the subject matter are a nullity. That is, when a court decides a matter without jurisdiction, the whole proceeding is as if it had never happened. Stated alternately, proceedings conducted or decisions made by a court are legally void when there is an absence of jurisdiction over the subject matter. If there is an absence of jurisdiction over either the person or the subject matter, a court has no power to act. If a trial court lacks subject matter jurisdiction, it does not have the authority to proceed or resolve the claims. A court devoid of jurisdiction over the case cannot hear the case, address or consider the merits of the case, cannot make a decision or order in favor of either party, and cannot render a summary judgment, as such a decision would be on the merits of the action, and it can't judge those merits. It can only dismiss a case for want of jurisdiction. Beautiful. However, a court can set aside orders it made before the want of jurisdiction was discovered, so it can set aside its orders. Observation: absent a patent and unambiguous lack of jurisdiction, a court having general subject matter jurisdiction can determine its own jurisdiction, and a party challenging that jurisdiction has an adequate remedy by appeal. Yeah, all right. Adequate? Really? A judgment by a court cannot be affirmed where the court had no right to act. Pending an appeal or certiorari, the nisi prius court is without jurisdiction over any issue pending on review, and its action upon these matters is coram non judice. Okay, well, a little rough on my Latin here, guys, so unless they give us a translation, we're stuck with that. Cases and the cumulative supplement. Washington courts generally follow the common law rule that a court lacking jurisdiction of any matter may do nothing other than enter an order of dismissal. Jurisdiction is essential to the exercise of judicial power, and unless a court has jurisdiction, it lacks any authority to proceed. And any decision, judgment, or other order is, as a matter of law, utterly void and of no effect for any purpose. Boy, that's putting it home. Okay, so now I think we can leave off here on effect of lack of jurisdiction, opportunity to cure defect. Because now we're going to get a little more in the weeds. But we'll go over this one on the further explorations of the courts through American Jurisprudence, 2nd edition, and some more on the jurisdiction here. What I wanted to do, though, is before we part, is to go over something in Black's Law Dictionary that I think we've been coming over quite a bit here at the evidentiary hearings, and see if we can find a good definition in here for all the listeners here today to leave with that. So bear with me as this very slow scan document moves ahead here, and I'm going to double check into the chat here. Yep. Give a second here. Yeah, be careful never to make a claim that is not a fact you can prove. Indeed. And more precious than gold. Yeah, welcome here. Says up in Canadian courts are completely lawless, don't even follow their own legal rules. Well, they're not common law courts either, so yeah, that's why Canada is Canada. It was founded on submission and compliance. Always rebut all presumptions. That is huge. Yes. Their presumptions they subject us to is insane. I have a form that is killer if anyone wants to file it in any case. Yeah, I mean, one thing is people need to do is not accept presumptions so easily that you need to challenge all evidence presented first. Oh, you're more than welcome, more precious than gold. Try to get this stuff out again, it's a learning procedure for me too. They even have a presumption that when we stand up for our rights, we consent to go to jail. Yes, rebut, yes. There's some that say that everyone in jail is there voluntarily, which is, can't say for sure. But yeah, the courts rule by assumption and presumption. Boy, you got to kill their presumptions before you walk in there, before they just take over with their assumptions for sure. Serve as a process. How do you receive jury duty notice? Well, that's a little bit different that doesn't apply to this topic here quite so much, but I don't know about that. And that's how the court had no jurisdiction to steal, trust private property. They embezzle the sale price of my home. Well, they'll have more one way to skin a cat for sure. Cannot rebut a assumption unstated. Yeah, but they do state them in more ways than one. You just have to take what they state, and as long as you can identify it as a presumption assumption, then you can rebut it. All facts can be rebutted. Truth cannot be a citizen that gives them jurisdiction. Status correction, indeed. A lot of that is by your actions too, and even coming in pro se, propria persona, have their other encumbrances too with them. So it's important to, I guess, be fully aware of status and how it's actually determined de facto. All right, let me get back to the Black's Law here real quick and see if it's we can get to the ends of the E's. This thing's really slow at scanning. I got to get a better scan document of Black's Law here. I myself prefer the hard copy because it has the little index stuff at the top of every page here that you can find a lot quicker and thumb through it. And plus, I just like books more than this digital stuff. But the nice thing about this is I could share it with so many people on the channel. So we deal with it. Almost there. We had estoppel here, which is one way that they could let's see here. There's very many kinds of estoppels, but just for a general a bar that prevents one from asserting a claim or right that contradicts what one has said or done before, or what has been legally established as true. So it's a bar that prevents one from asserting a false claim, really. It contradicts what they said or done before, or what has been legally established as true. So it prevents falsehoods. A bar that prevents the relitigation of issues. An affirmative defense alleging good faith reliance on a misleading representation, and an injury or detrimental change in position resulting from that reliance. So that's what the estoppel is. That's from the 16th century. Now, there's going to be a lot here. Estops to come as, well, we won't get into too much here. And using the term estoppel, one is, of course, aware of its kaleidoscopic varieties. One reads of estoppel by conduct, by deed, by laches, by misrepresentation, by negligence, by silence, and so on. There's also an estoppel by judgment and by verdict. These, however, obviously involve procedure. The first named varieties have certain aspects in common, but these aspects are not always interpreted by the same rules in all courts. The institution seems to be flexible. All right, so you see all these estoppel by deeds, assign or estoppel, by judgment, by laches, equitable doctrine by which some courts deny relief to a claimant who has unreasonably delayed or been negligent in asserting a claim. File wrapper estoppel, prosecution history. Okay, so a lot of these are going to be procedural, as I said. As we get down to the end here to evidentiary. Getting close. Evidence. Come on. There's a lot here, subheadings under evidence. Okay, and you should know all these. Signature evidence, highly distinctive evidence of a person's prior bad habits. All right, evidence rules. Airy fact, evidentiary hearing. Oh, Lord, see hearing. All right. Well, we went over estoppel. I'm not going to get to hearing and look for it there. It could take us forever. We'll go here real quick, see if it gets there. If I get lucky. H. All right, we're almost there. All right, let's see where we're at. Here, all right, so we're almost there. Hearing. Hearsay. Evidentiary hearing, finally. 1952, wow, so this is pretty current. A hearing at which evidence is presented, as opposed to a hearing at which only legal argument is presented. See administrative proceeding. Important to know this, and this is something since 1952, interesting. A very powerful right we have to have this evidentiary hearing, especially concerning jurisdiction, which is the topic for tonight. And at that, I would like to thank everyone for attending. We're going to go through the last of the chat here, see if we get everyone addressed, which I believe we have. I'd like to thank everyone for coming out tonight. Please encourage you to hit the like and subscribe and hit the bell notification so you can be alerted anytime there's more of these presentations here involving American jurisprudence and other aspects of common law. And we could share some more comments and input. It's always been a enlightening and encouraging experience to see so many people that are interested in this. Although, administrative hearing is not criminal or civil. Although it seems like everything's become administrative these days. Even criminal hearings have become commercial to some extent. But that would be a topic for another time. Again, I want to thank everyone for coming out and to keep studying some of these things we went over here, because I believe that The more informed, the more people are more informed of these elements of our judicial system and common law, the more that we can preserve all the benefits that have been passed to us, and hopefully we can, again, to convey to our posterity the benefits of liberty for everybody. On that, I'd like to thank you all for coming, and we'll see you on the next one. Peace out.